I don't know how much you know about these periodic presentations, but as a faculty we got together and we're talking about different strategies for helping you folks prepare for the bar. And one of them was to, on occasion, have one of us give a short 1 hour, I guess, presentation on some subject that we could select. And the primary criterion for selecting it would be whether this particular subject would be particularly helpful on the bar exam. Having spent decades teaching evidence, but also collecting the released bar exam questions concerning evidence. I do that in all the classes that I teach. Something struck me because, again, they asked me to do this in the general area of evidence. And I sat down and said, okay, out of all of these, and literally I've read through probably hundreds of them over the years, is there some particular concept that you see over and over and over again that the bar examiners seem to focus on in the area of evidence? And more specifically, I selected, just when they asked me to do this, hearsay in general, because it's been my experience that most students have, out of all of the rules of evidence, seem to have a greater problem wrestling with the concepts dealing with hearsay. And as I've told some of you, quite frankly, when I was in law school, I never had any problem with it. And I came to a conclusion about why that's so. It's not because, believe me, that I was brighter than anybody else, and certainly brighter than you. The conclusion I came to, and I still believe it to this day, is that, this may sound counterintuitive, but the brighter the student, the more difficulty they seem to have in grasping hearsay. And again, that sounds counterintuitive, but here's how I came down on the side of this conclusion. And that is that there's a strong tendency in this area of evidentiary law to overthink it. To overthink it. And as some of you have spent time with me talking about evidence, one of the things that I tried to convince you of is that with very few exceptions, the rules of evidence are nothing more than a codification of rules of behavior based on the social mores, based on concepts of democracy, all of this that are simply codified in the rules of evidence. About 95% of them are nothing more than codification of pre-existing rules, common law rules of evidence. And hearsay is one of them. Hearsay, the problem of hearsay has been around forever. And we know, of course, that the main problem with hearsay, why there is a general hearsay prohibition, is that there's a concern about reliability. Meaning if you're introducing a statement, an out-of-court statement that meets the definition of statement for a particular purpose to prove the truth of the matter asserted, but you don't have the declarant, the originator of the statement there, there's this concern about, well, as triers of fact, how is it we can test whether we ought to believe this or not? How is it, we can't cross-examine a chair, so how is it that we can evaluate the reliability of the content of this statement? So, of course, consequently, we've developed rules dealing specifically with hearsay. But one of the approaches I suggest that you take, and this is, I'm coming back to where I started, why I picked the definition of hearsay is that I came to the conclusion after reviewing literally hundreds of released questions that most of them at their core could be answered if you knew and really had a grasp on the definition of hearsay. Because in practice, most of your hearsay problems are going to be resolved in one of two ways. There's a number of ways, but one of the two ways is the major way. One of them is that you define out the problem outside the coverage of hearsay. The other, of course, is that if you can't do that, then and you admit it's hearsay, well, then you look for an exception under 803 or 804 primarily. But what I want to focus on today is the definition of it. And the handout I gave you from Maue's evidence law, it's specifically written for trial practice classes, but I think it does a wonderful job of giving you a nice overview and nice examples. And if you go to page 26, it's the second page in the handout, I basically have, he lays out a couple examples that I think go right to the heart of hearsay. Now, we know that hearsay is defined by Rule 801, and it starts out by defining what a statement is. Because again, if it's not a statement, that meets the definition of 801, then right away, you don't have a hearsay problem. Now, one of the problems, the perennial problems that the law has, and students primarily have, is that they start out reading the definition of 801A, which is a definition of statement. And it talks about every statement, to be a statement in this context, has to be an assertion. What does that mean? Because you'll find nowhere in the rules of evidence, certainly not in Article 8, and frankly, you won't find it in the congressional testimony and the committee notes, a definition of assertion. But through spending a substantial amount of time over the years reading hearsay cases that address this issue, I've come to the conclusion that the best way to describe it in this context is an assertion is a statement by somebody that is expressing a belief in the existence of something. John shot Susie. Okay, that's an assertion. If the person is intending that to express his or her belief, that would fit into an assertion, meaning obviously expressing his belief as to who did the shooting. Okay. Now, you cannot right away, you sit back and say, well, what's not an assertion? Because they talk about out-of-court statements and whatever. Well, frankly, there are a lot of interesting and obvious, I would hope, examples of non-assertive, verbal, written, as well as nonverbal conduct. And that is a question. A question is not an assertion. Therefore, let's say in the factual setting that you have, what they're arguing about is the admissibility of a question that a declarant asked somebody out of court, and they're asking somebody to repeat that question. And there's an objection to hearsay. Overruled. Because it's not a statement. And the reason it's not a statement is that it's not an assertion. When you ask a question, you are not expressing your belief in anything. In fact, it's quite the opposite, I would guess. So once again, that's one way of removing yourself from a hearsay problem, because it is non-hearsay. Because if it doesn't meet the definition of 801A as a statement, it's not hearsay. That's the end of your hearsay analysis, and then you go through the rest of the facts to resolve that. Okay. Also, again, the intent behind the assertion. If the declarant, the person who originates the statement, intends their words to be an assertion, then obviously that's going to meet the definition of an assertion. Meaning that somebody could see some startling event and go, oh my God, I can't believe that he's going to lose his leg because it collapsed on the basketball floor. What was it, last weekend, where that player just, his leg basically crumbled. Is that an assertion? It could be. If it could be that this person has truly believed, he's asserting that he believes that this player is ultimately going to lose his leg as a result of this injury, that is asserting a belief in the existence of something. That is, that he's going to lose his leg as a result of the injury. Or it could just be a way of expressing his shock and excitement. Meaning that maybe he doesn't believe at all that's going to be the ultimate outcome. Well, that would mean, of course, that he is not, it's not his intent to use those words to express a belief. It was just his words to use to express shock. Now, you might say, well, okay, let's say you get a sample, a question like that, and you have to determine whether it's admissible as hearsay or non-hearsay. Well, there's two ways you can go. One of them, of course, is you can say, well, if you can make an argument that it's an assertion, then I would say that it's going to be admissible whether he's around or not. And the reason, of course, is that if you sit back and say, yeah, the facts suggest that he truly believed that, well, that's an assertion. It's a statement that was made out of court. And if they are trying to introduce it, whoever is the proponent, trying to introduce it for the truth of the matter asserted, that, yeah, he may very well lose his leg as a result of this, or whether maybe the issue is whether this person believed it, then yeah, it's hearsay. Does that mean it's inadmissible? Well, that comes to one of the second promises I made my evidence students, and that is, in violation of it's almost an urban myth, that this belief that if it's hearsay, then it's inadmissible automatically. I have suggested to you that by the use of evidence, the rules of evidence, you can get in about 95% of every statement you want to get in, either as hearsay or non-hearsay. Well, here we have a situation where it looks like hearsay to me. Well, is it admissible? Of course it's admissible. It's an excited utterance. No argument about that. He is making this startling event. He's making this response, and while viewing the startling event, and while he's under the excitement, it could also be admissible under a state of mind exception under 803. Point is, if it's a hearsay, if you come to the conclusion it's hearsay, then you go down a certain path, and that is, if it is hearsay and you're introducing it, meets all the definitional requirements, then the next question is there some exception out there? Well, the exceptions that you're probably most familiar with are 803 and 804 exceptions. But there's another set that are not called exceptions. They are confusing. And I'm talking about with quotation marks around them, the exceptions set out in 801, D1, and D2. These are, I guess what you could call them exceptions, based on policy considerations. For example, the 801 D2 exceptions are out-of-court statements made by a party, and they're called party admissions. And you know from reviewing that rule that if it meets the definition of a party admission, and there's 5 different ways of meeting it, the opponent of the declarant can introduce it against the declarant. And they're wonderfully flexible. Basically, if you can establish that relationship as well as relevance, it goes in, even though it would meet the definition of hearsay. An out-of-court statement, and statement meaning, of course, an assertion, that you're introducing it through somebody who's going to repeat that out-of-court statement in court for the truth of the content of the statement. On its face, you'd say, well, that's hearsay. Well, for policy reasons, the law defines that outside the coverage of the hearsay prohibition. So that's the second way of avoiding it. First way is you define the statement, if you will, and I'm using quotation marks around that, outside the coverage of the definition of hearsay. If it's not, it doesn't meet the definition of statement in that context, then it can't be hearsay, and you're going to have to deal with whatever else is out there in terms of the facts they give you in terms of admissibility. If it is hearsay, it appears to be hearsay, you take 2 different routes. You have your choice. One is, if you want to admit it's hearsay and it's pretty clear it's hearsay, well then take a look at 803 and 804. Those are the exceptions. And of course, under 803 and 804, you're going to, one of the things you're going to have to know, and they'll give it to you in the facts, is whether the declarant, the originator of the statement, is available at trial. Under 803, whether the declarant's available for cross-examination is irrelevant to admissibility under the rules of evidence. I'll get to this in a second here. Under 804, of course, the unavailability for cross-examination of the declarant is a prerequisite to admissibility. So under the set of facts, they'll let you know whether the declarant is available or not. Now, here is what's coming up, and it's been they've had about 2 questions for about the last 5 years that have brought this issue up. You know what hearsay is, you know how it works, you know there's exceptions out there, and you come to your analysis and you say, okay, I've walked through this. I've walked through this fact situation, and of course the question is almost always, is this statement admissible? They don't refer to it as a hearsay statement. At the end they simply, is this statement admissible? So you go through your analysis, and let's say that you come to the conclusion, correct conclusion, that's hearsay. You walk through 803 or 804, and sure enough, you find an exception, it's admissible. And so you might just automatically look for one of the 4 answers that simply says, yes, it's admissible because it falls under an exception. But here's what they've been doing, and it's simply a reflection of the radical change that has taken place in hearsay jurisprudence since the Crawford case, is that there's one more issue you're going to have to deal with. But you're only going to have to deal with this issue if the declarant, the originator of the statement, is not available to testify, and that is this confrontation issue. Again, that is now kind of the popular thing that they want to bring up, and what it comes down to is that you can have a hearsay statement that meets the definition of hearsay, and in fact is admissible under the rules of evidence, 803 or 804. But the question is it admissible under the Constitution, specifically under the 6th Amendment Confrontation Clause? Because you can have hearsay statements that are admissible under the rules that are inadmissible under the constitutional considerations. So the next step, of course, you take is, okay, we've determined it's hearsay. We've determined that under the exceptions or yeah, that's right, we're going to use this as an example of hearsay. So under the exceptions, it would be admissible under the rules. Next question is, and again, this will be limited just to criminal cases, is it completely admissible, meaning that it's also admissible under the Confrontation Clause? Well, how do you answer that? The way you answer it, of course, is you ask the next question, and that is this hearsay statement testimonial or non-testimonial? Because if it is non-testimonial, then as long as it meets the requirements of one of the hearsay exceptions, it goes in. But if it's testimonial, and that's a term of art that was created by the United States Supreme Court in the Crawford case, if it is testimonial, then according to the Supreme Court, the Confrontation Clause should be literally interpreted, meaning that if it is testimonial and the declarant is not available to testify, then of course it's inadmissible because it would violate the Confrontation Clause. There's some exceptions, for example, forfeiture by wrongdoing, things like that. But the general rule is, if it is determined to be testimonial, then whoever is proffering the statement has to make the declarant, the originator of the statement, available for cross-examination. So, let's start the basics. And this is based on the hypothetical Moe gives you. You have a victim, you have a defendant, you have, and I call it John here, who is, they're outside the court. This is on a timeline. At the beginning of this timeline, allegedly the defendant shoots the victim. And you have John there, who allegedly is standing right next to it. Now, you go to that page 26 here, and they give you, at the top there, they start with these examples to make distinctions as to what is and is not hearsay. And these are, they're great because they go right to the heart of my suggestion in terms of dealing with hearsay problems. First of all, by trying to define the problem outside the coverage of hearsay, and if that doesn't work, then look for an exception. So you have these examples based on this. Each of the examples, the witness is testifying in court. The witness, of course, is Jane here. She testifies, I saw the defendant shoot the victim. Okay, is that a hearsay statement. I mean, what she's referring to is something that took place outside the courtroom, and then she's testifying to it inside the courtroom. Well, it's a statement in the sense of everyday language, but it's not a statement under the definition of hearsay, because the statement has to be not only an assertion, which I don't think is any problem here, it's clearly an assertion, but it has to be an assertion made outside the courtroom in the trial or hearing in which it's being introduced. Okay, did she make this statement and is on the stand to repeat it, some statement she made outside the courtroom? No. She's simply testifying from personal knowledge. They asked her, basically, what'd you see? Well, I saw a defendant shoot the victim. She's doing nothing more than testifying from personal knowledge. She is not, her testimony is not based on the repetition of a statement made by her or anybody else outside the court. And if you think about it, if that were not true, then every bit of testimony based on personal knowledge would be a statement. And we know that can't be. Okay. Now, let me freeze frame here. Question. Okay, then let's go to the second one. John told me he saw the defendant shoot the victim. Jane says that John told her outside of court that he saw the defendant shoot the victim. Okay, is that hearsay? Well, it's certainly a assertion. The statement made by John is an assertion. It's assertion that this is what somebody said, the existence of something, and it's made outside of court. Well, here's where he doesn't, Malway, who's a genius, assumes certain knowledge here. And here is the key question when you get to this issue about, okay, it's a statement that meets the definition of statement, assertion. It was made out of court. The next question you have to ask is, and this happens, as you well know, with almost every piece of evidence when you're trying to determine admissibility, is what's the purpose it's being introduced for? Okay, if this is being introduced as part of the evidence to prove that the defendant did in fact shoot the victim, there is no question that this is hearsay. No question. But how about this is simply being used for impeachment purposes, to impeach maybe John, because let's say John on direct examination testified to something that contradicts this. And of course, you know, if it's used for impeachment only, it means, of course, that you, the person who's using it for impeachment, not asking the trier of fact to believe this statement over another statement. You're simply, since you're using it for impeachment only, you're just simply using it to argue to the trier of fact that, hey, this guy was asked the same question about the same subject and gave two diametrically opposed answers. Therefore, you can't believe anything he says. You're not introducing it for the truth of the matter asserted. You're introducing it for a different purpose. And of course, that drops it outside the definition of hearsay. Okay? Because it's only hearsay if it's an assertion that meets the definition of a statement, and it's made by a declarant outside the trial or hearing in which it's being introduced. And thirdly, that it is being introduced for the truth of the matter asserted, meaning that they're introducing it, asking the trier of fact to believe the substantive content of that statement. Meaning, if they were offering it, to ask the jury to believe it as proof that John shot the victim, clearly would fall into the definition of hearsay. If it's being used as impeachment only, with the emphasis on only, then it's not. Because you're not asking the trier of fact to even believe the statement. Just saying, hey, look, he talks out of both sides of his mouth. You can't believe anything he says. Okay? Now, but John gave me a note which said, I saw the defendant shoot the victim. Well, that doesn't really change anything in terms of its definition. It's simply a written assertion. And if all the other elements are there, and we assume it's being introduced for the truth of the matter asserted, okay, it's hearsay. Now, the D here, I met John and asked him, did you see the defendant, and this is Jane talking, I met John and asked him, did you see the defendant shoot the victim? John nodded his head. Okay. This is the third way you can meet the requirement of the definition of statement under hearsay. And that is, it's nonverbal conduct intended to be a substitute for spoken or written assertion, meaning that it takes the place of communicating an assertion, a belief. Instead of using the spoken word or the written word, you're using conduct. Now, the key to this, of course, is the intent. Now, if when John asked, or when Jane asked John this question, let's say John has a medical condition that makes him shake all the time. And she asks him this question, and his head shakes back and forth. Well, was that an answer to the question, or was it simply an involuntary physical response to a medical condition that has nothing to do with his intent to communicate? If it's that, then of course it'd probably be inadmissible because it's irrelevant. But if John was using that in our culture, which is very acceptable in our culture, as a substitute for saying yes, well, that's an assertion. But again, it's only if John intended it to be so. All right. Now, here's something that it's not in the rule. In fact, I've seen very few commentators talk about it because I think most of them assume that students of evidence law would just automatically come to this conclusion. But all three of these, you know, at the very end of that sentence under the definition of statement, it talks about if it is intended to do so or be so. That intent, in terms of making it an assertion, applies to all three forms. You could read this rule saying, okay, that intent, to have this conduct, nonverbal conduct, that intent to have that as a substitute, that's the only intent you would have to show if you're the proponent. That's not the case. For all of these three, all three of them, the spoken word, the written word, and the conduct, to meet the definition of an assertion, which meets the definition of hearsay in this context, have to be intended to be an assertion, okay? So just because somebody speaks some words that sounds like an assertion, unless that person intended it to express a belief or the existence of something, it's not an assertion. Okay, so this intent applies to all three of these. Now, you might say, well, how would you do that? Well, in most cases, it's how you prove almost anything that is a mental process. You use circumstantial evidence. I mean, how is it we, in any situation, determine a person's intent to do something or not do something? How do we prove that at trials? Well, the overwhelming majority of time at trials, you prove it through the use of circumstantial evidence. You look at the totality of circumstances, if you will, to come to some conclusion as to what this person was thinking and intending. Same thing with, there's nothing different about it in terms of establishing the intent behind what is purported to be an assertion slash statement. So, you have Jane up here. Ask yourself the question, the statement that's made out here, is it intended to express the belief in something? One of the statements that we went through in the examples. If the answer is yes, sounds like an assertion to me. Was it made outside of court? Yes. Under this hypothetical, is the declarant available? Well, John, let's say he is available. Let's say he is available for cross-examination, and they're introducing it for the truth of the matter asserted. Does that change anything? And this is another hypothetical that's not unusual that they come up with. And what it is, it responds to this belief, a pretty widespread belief out there, that if a declarant is not on trial, but in the courtroom, open for cross-examination, available for cross-examination, then if you ask that declarant to repeat their statement, or for that matter ask any person to repeat the declarant's statement in that trial, then it's not hearsay. And the response is that it's not hearsay because you have the declarant available for cross-examination. Absolutely wrong. Absolutely wrong. Even if you have the declarant present in the courtroom, available for cross-examination, if it meets the definition of hearsay, it's still hearsay. And the fact that he is or she is available for cross-examination doesn't change it. Why is it that you don't usually run into that problem? Well, the reason, of course, and we can use this as an example, is that you avoid your hearsay problem by not asking them to repeat it. Remember, one of the examples is John told Jane that he saw the defendant shoot the victim and kill him. Okay, and they're asking Jane to repeat John's statement. Well, what happens if John is available to testify on cross-examination at trial? Or even more importantly, let's say it's John up there that they have on the witness stand and ask, do you think they're going to ask John to repeat his statement and create a hearsay problem? I wouldn't think so. Instead of saying, repeat what, unless it has some separate need, relevancy, or use, they're not going to ask John, what did you say to Jane in regard to the shooting of the victim? You're simply going to lay a foundation of personal knowledge and say, after you lay the foundation, what do you see? And they'll be testifying based on personal knowledge, not having to rely on repeating a statement that was made out of court. The fact that the declarant is available to testify doesn't change the nature of that statement if it meets the definition of hearsay. Hearsay is hearsay. But again, you don't run into the problem, and you don't find a whole lot of cases out there because the people who are conducting it, the practitioners, simply don't ask them to repeat it. They simply ask the witness to testify to the substance of what they're trying to get to based on personal knowledge versus what did you say. Okay? Now, freeze frame again. Now, they give you a list of questions here that I really think if you follow, you're going to come out all right. And I'm talking about going back, if you're not already on page 25, you should always ask the following questions. And again, if you go through this process, you're going to come to, I think, the correct conclusion about the nature of the statement 99% of the time. There's probably some factual situation out there that we might, if we spend a lot of time thinking about, that would fall outside this coverage, but I kind of doubt it. Now, the other thing that is I've often thought was unfortunate terminology, and that is the part of the definition of hearsay that refers to introducing it for the truth of the matter asserted. What does that mean? Okay. Well, that goes to one of the crucial parts of your analysis, which of course is the answer to the question of what is the proponent introducing this for? Okay, and we talked a little bit about that in terms of, for example, impeachment versus as substantive proof. Well, again, I've seen a number of different formulations of this by commentators over the years, using different terminology to try to explain what this means. But it frankly comes down to, I think, the answer to this question. Is the proponent of this out-of-court statement, introducing it, and asking the trier of fact to believe that the substantive communicative content of this statement is true. If they are asking Jane to repeat John's statement that he saw the defendant shoot the victim, are they introducing that statement, asking the trier of fact to believe the communicative content, that is, that John shot the victim, as being true? If the answer is yes, that's the last part of your definition of hearsay that is now complete. And again, if it, once you arrive at the conclusion that it is hearsay, and for the moment putting aside confrontation issues, Crawford issues, then the next thing you have to ask is, okay, if it is hearsay, does it fall under any of the exceptions? The unnumbered exceptions under 801 D1 D2, does it fall within any of those? If the answer is, and of course those exceptions are exceptions that where it's part of 801 that says that the following statements are not hearsay, though when you look at them, you go, well, of course they're hearsay. But again, they're not hearsay, in quotation marks, for policy reasons. So let's say your statement that meets the definition of hearsay under 801 doesn't fall under any of those two paragraphs. Well, the next thing you ask, of course, is, does it fall under any of the exceptions, 803 or 804? And of course, if you can lay the foundational requirements for whatever it falls into, then it will be admissible as substantive proof for the truth of the matter asserted. Okay? Now, when you get to the exceptions, and this is particularly true in 803, first of all, 803, they're the most numerous exceptions. Remember, in fact, they started out 803 by saying that the availability of the declarant at trial to testify is irrelevant to admissibility. It's irrelevant to admissibility. So whether the declarant is available for questioning at the trial that the declarant statement is being introduced at is irrelevant as to admissibility. Okay. So you get this out of the way. It's very broad because you don't have to worry about unavailability other than, and I said we'll use another day to talk about confrontation issues. Then you take the facts that you have and say which exception, if any, does it fit into. Okay? Now, sometimes they will give you a factual setting that looks like right on its face, and it's intended to trigger this. You'll look at it and go, oh, immediately, this is clearly an excited utterance. It clearly falls in under that 803 exception. But if you read a little closer, you'll see that there's one of the foundational requirements missing. Okay. Well, number one, if you pick the wrong answer and says that it is admissible under something else or under that, then obviously it's a wrong answer. Read it closely and then back up and think about those foundational requirements, because more often than not, it will be admissible, but under something that's very similar. That's why so many of the exceptions, especially under 803, they cover statements that might be admissible under 1, 2, 3, 4 separate exceptions. You take an exception under 803.4 for statements made for purposes of medical diagnosis or treatment. Quite often, just due to the nature of the factual settings where this comes up, especially in criminal cases, it could be admissible for that, under that exception. It could be admissible under an excited utterance. Let's say it is a rape victim in an emergency room who is still in the process of going through the psychological trauma of this startling event and make statements. It would be admissible under that. How about state of mind exception? It could be admissible under that. So what you do, of course, is walk through in your mind the foundational requirements for each of these and say, which one does it fulfill? And what you will find, and they set it up this way, you'll find that it only, even though it looks like it might fit into one that, and then they set it up where it draws you in, you're going to find out there's one missing there, but it fits perfectly into a similar one. Because they're, again, simply testing you about your knowledge. Now, what am I talking about? I hope this is a stupid rhetorical question. What am I talking about foundational requirements? Well, what I'm talking about, and all of you have been through it, is that for each one of these exceptions, it's limited to certain types of statements made under certain types of circumstances that are usually limited to certain types of subject matter. How would you study for something like that? Well, what I'd suggest, and I see a lot of familiar faces here, that courtroom evidence manual that I use, the handbook, if you go to the back of it, and you can find this in a lot of other secondary sources, you can go back to it, and they have a list of each one of them that's broken down into its elements. Frankly, they're not very long, they're not very certainly sophisticated or complex, and that's how you go about learning them and then being able to make these distinctions. The distinction between a present sense impression versus a excited utterance, for example. You need to know the foundational requirements. Now, since we're running out of time, what I'd like to ask you folks, what is, for each one of you, what is the question that bothers you the most about hearsay, that gives you the greatest problem or makes you wonder about it? What is it that bothers you the most or is giving you the most problem in your ability to get your hands around this concept? There's no stupid questions. Nobody has any. Yeah?
So you're saying 95% of things you can generally get through under hearsay?
Yes. Well, no, 95, my belief is you can get 95% of out-of-court statements in, sometimes as hearsay, sometimes as not as hearsay. For example, an out-of-court statement that you're using only for impeachment. You don't care about whether they believe the content. Well, that's an out-of-court statement you're getting in that's outside the coverage of the hearsay rule.
Okay, and that's in reality as far as the outside world. But is it true?
Oh, absolutely.
Okay, but is it true for, are you finding that for the bar examination and on these multiple choice? Are you finding that to be true, that they're trying to just get us on the exceptions to try to get it? I mean, I know
yes. The two things that they focus on are your knowledge of the exceptions and prime. Yeah, I'd say both 803 and 804. That's number one, and number two. Now it never used to be this way, but number two is this Crawford issue.
That's the second thing. Can you give me an example of that?
Okay, and this is caused and it still causes tons of confusion, and the famous Crawford case where the issue came up. Well, if you have a hearsay statement, it only applies, you only have this concern in criminal cases, because Sixth Amendment only applies in criminal cases. If you meet the foundational requirements for one of the hearsay exceptions, is that all you got to do to get it in against a defendant? And it used to be, the answer used to be, yeah. But not anymore. Under the new cases that Crawford and its progeny, they said if it is, there are some statements that even if you meet the hearsay exceptions, you still are not necessarily going to get it in. Well, how do you make the distinction? Well, the court came up with a whole brand new analytical approach. They say, well, if you already have come to the conclusion that it is hearsay, and you've come to the conclusion that it's admissible under the rules, and again, this only applies in criminal cases, the next question you have to ask is, and it only applies again in these situations where the declarant's not available at trial, then you have to ask the question, does this hearsay statement fall into one of these two categories? Is it testimonial or non-testimonial? If it's determined to be non-testimonial, then the fact that you established the foundation requirements for the hearsay section, it goes in. That the confrontation clause doesn't cover those types of statements. An example of a, currently at least, of a non-testimonial statement that falls outside the coverage of the confrontation clause is a recorded statement of somebody calling in on a 911 line reporting an ongoing emergency. Okay? You know, somebody, let's say somebody is calling in and said, oh, my God, officer, I see John Smith is chasing Susie Q down the street shooting at her. Fast forward, John Smith's now on trial for the murder of Susie Smith, or whatever. Let's assume that the declarant, the person who called in, is not available to testify. It sounds to me like it would fall under the excited utterance exception to the hearsay. But again, what happens if the defense says, wait a minute, even though it falls under the excited utterance exception under 803 for admissibility, I have a right under the Sixth Amendment to confront that declarant. That's where the rub comes. If it's considered to be testimonial, and then they say, yeah, you're right. Unless the prosecution produces her, the declarant, whether it's a him or her, doesn't make any difference, then you can't get the statement in. If it's non-testimonial, which they've determined that 911 calls of this nature are non-testimonial, or non-testimonial, then you don't have to worry about it. Now, here's the problem. In the Crawford case, which is an incredibly interesting opinion, it gives you, it's more of a history lesson than anything else. They go all the way through this stuff about how they're throwing out Roberts versus Ohio, which was the key Supreme Court decision on hearsay for decades, and saying, okay, this is the new analysis for Sixth Amendment concerns in criminal trials. And we've made these two new categories, testimonial, non-testimonial. However, here are examples of statements that are testimonial. Here are examples of statements that are non-testimonial. But we're not going to, and we can't at this time, give you a definitive answer as to the different tests that you can apply to make a determination if it's testimonial or non-testimonial. We're going to leave it for another day. You folks have all read cases like that where you go, yeah, right. But that's what they did. But what they're going to do is give you a question that has adopted the most commonly adopted definition of a testimonial statement, and that is that you ask this question: when the declarant made the statement, would a reasonable person who would be making a statement under those circumstances, could have they concluded that this statement might be used later in a criminal prosecution? If the answer is yes, this is the most common test that's been adopted. If the answer is yes, then that's testimonial and your Sixth Amendment rights kick in. And they use, in fact, the 911 call is a good example. They say, well, when somebody's calling in reporting an ongoing emergency like that, a reasonable person who's in that situation, they're concerned, they're probably not even thinking about later down the road it's going to be used as evidence. What they're thinking about is, my God, here's this maniac here shooting at this woman, we need help right now. So consequently, they say that falls in. But there's other tests, I guess you could call it, but they're not going to ask you questions about that because they are so, right now, in a minority situation in the sense that not every jurisdiction is adopted. The one I just gave you is adopted by all jurisdictions, and that will be the one that they'll focus on.
Quick question, Professor Hagel.
Yeah.
The release questions that are now being used for the vendor courses or any other courses, how far do they go back? How current are they? Are we using questions that are going to have some utility once we sit for the
Good question in terms of, because it goes to how representative they are.
Absolutely.
And whether, in terms of efficiency of study. There are two groups of questions, and the people who are doing, I don't know if the people who are teaching the in-house bar review course makes this distinction. There are two different types of multiple choice questions that are associated with the multi-state bar exam floating around out there. One group are actual questions that have been used and are released by the people who put together the bar exam. The other group of questions are not, they were not put together by the people who put together the multi-state bar exam, but they're put together by the vendors. And they are very representative both in structure and content, and they're up to date. Now, that's why I say that I've spent, God knows, how many hours every year going through the released ones, because that's the ones that I think give us the best idea about what to expect. And the vendor stuff is great too. But the release questions, what I look for are patterns. Saying, okay, in the area of, in my different areas, evidence, torts, criminal law, criminal procedure, things like that, I look for patterns. For example, when it comes to hearsay, first of all, out of this group of evidence questions in the bar exam of 2011, did they ask any questions about hearsay? Okay, the answer is yes. Number two, what are those questions? What do they deal with? And then I go back and say, okay, I asked the same question and reviewed the 2010 release questions. Is there any similarity here? And that's where I pick up on these patterns. So I would say that I wouldn't go more than, I wouldn't go past 2008 backwards. Yeah, I think you'd be safe because there has to be some limit. I'll stay as long as you got questions. Any other questions?